Hi, I'm Christy Salyers. I'm the supervising attorney for the Guardian Ad Litem program, and I'll be covering the legal portion of the materials. We have the objectives up here on the screen, and what we'll learn to do this evening is recognize the different hearings and what occurs at each point in the dependency process, and understand the different permanency options for children that are in dependency court. Now, as you may recall from the first class, the Mary Ellen story. Well, 100 years have passed since what I'm going to cover tonight, and we have the Child Abuse Prevention and Treatment Act of 1974. Okay, what that did was it created a national center on child abuse and neglect. Okay, there were federal funds given to the states for this, and as you can see in your PowerPoint, that it requires states to do certain things to obtain that money. One of those is to have laws regarding reporting child abuse and neglect, to investigate the reports of child abuse and neglect, educate the public, and to provide a guardian ad litem for every abused and neglected child whose case results in a judicial proceeding. That's what makes our role so important with the court. And lastly, to maintain confidentiality of those records. And you'll hear that covered in many of the different classes through your training is confidentiality. Okay. The Adoption and Safe Families Act of 1997, there's three key principles. Safety of the children. Foster care is supposed to be temporary. It's not a permanent placement for children to grow up. And permanency planning should start as soon as the case does. Okay, so how does a case enter the system? Many of you may have seen the posters, bulletin boards, or billboards, I should say, 1-800-96-ABUSE. It's the Florida Abuse Hotline. So generally, a call will come in regarding the abuse. So first, who is a mandated reporter? Well, people in certain professions, teachers, our staff, you once you become a guardian ad litem, law enforcement, doctors, nurses. But the statute actually says anyone who has knowledge. So really everyone has an obligation to report abuse if they see it of a child. Now, when the call comes into the abuse hotline, they then send that call out to the local agency. And what they have is a child protective investigator. You'll have a lot of acronyms as you go through the training, so you won't pick them all up immediately. But child protection investigator, we refer to a lot as CPI. Now, the CPI must see the child within 24 hours. Now, if the phone call to the abuse hotline or the report is circumstances that would be immediate, need immediate attention, they have to go out immediately when they get the call. And many of those generally would involve law enforcement, and that's how the CPI would also be called out if the circumstances were such that they needed to call the police out. Okay, so there are three findings that the investigator can make. One of those is no findings, or unfounded, unverified, or no indicators if there's no findings. We'll cover the other two in a few minutes. And if there's no findings, that's pretty much it. Now, they could offer services. So sometimes abuse calls go out and the case doesn't always end up coming into court because the CPI has the ability to offer services, whether diversion services or offer voluntary case plans, task for the parents to do, whether it be to clean up the house or fix some safety hazard. They are able to do that. Now, if there's an immediate risk to the child can be removed from the home right then. Now, the CPI, if there's another parent that lives in another residence as a possibility for them to place with, or another relative or a friend, information, if the parents provide information to them, or the child's old enough to provide information at that point, they are able to look into that person's background and possibly place the child with them so they don't have to go into foster care. Now, if they do remove the child, the shelter hearing must take place within 24 hours if the child's removed. And then the court will determine whether there was probable cause. So even though the investigator that goes out can make a decision to remove, it has to be reviewed by the court. Okay. So what does the CPI do when they get the call? They'll go out, they'll talk to people that are present. Depending on the situation, if it's an immediate response, the people involved are still there to ask questions. If it's later, they may talk to people that know the family, or neighbors, or people at the school teachers, and then they'll make the following determinations as listed on the screen. So, as I mentioned before, there were no indicators, so it was unfounded, not verified. Verified, it did happen. Some indicators is it likely happened, which means there was some evidence, there was something there. They couldn't actually determine exactly what happened, but something happened. Okay. So the main thing when the CPI is out there, what they're assessing is the risk to the child. You'll hear now safety, safety, safety. Is the child safe to leave there? If they don't believe they're safe, then the child would be removed from the home. Okay. So the things that the CPI could do at the end of the investigation, and once they've assessed the risk, is to leave the child there and put services in the home. But that's only if it's voluntary. So the parents have to voluntarily agree to do that. Or they could offer no services. I'm not sure what type of cases that would be. It would probably be more on calls that needed to be answered, but the children are of an age that they're able to report themselves. You could have, a 16-year-old that's capable of notifying authorities if something were to happen or if they were put at risk or in danger. They can remove the child from the home and, as I said, place with relatives or non-relatives or in foster care. Preferably, it's always better to have the children placed with relatives or non-relatives, someone they know, and not in foster care, because it's very... it affects the children a lot. I mean, imagine yourself if someone showed up at your house and said, come on, you have to leave, let's go, and they take you to somebody's house and leave you with them and you don't know who they are. I mean, all of your stuff, all of your things. I mean, kids are taught, especially when they're younger, kids are taught that, to stay away from strangers and don't go places with strangers, and all of a sudden the police, the CPI, case managers, whoever is now showing up, taking you to somebody's house that you don't know who they are. So you're in the car with them. You may be separated from your siblings, and you're all alone. So again, it's why I say relatives and non-relatives, it's always better. It's less traumatic for the child to be placed with someone that they know. And the CPIs, they don't make the decision if there's a removal in a vacuum, and it's not all their decision. There's an attorney on call for the department. In our area, it's the state attorney's office that works the dependency cases. So the child protection investigator would call one of the attorneys that they have on call, because a lot of these things happen in the middle of the night, and determine whether they believe there's legal sufficiency to remove. Now, if they don't actually remove that night, there's no petition before the court. Nothing's before the court yet. So if they believe there's enough there, though, that the child should be adjudicated dependent and the parent should work a case plan, services to fix whatever the problem is, then they're able to, what we call a direct file of the dependency petition. So in that case, the children stay in the home, but there's still a case that comes into court. And that's how a case enters. So that's where we're going to go from, is if the CPI did either shelter or the state attorney direct filed a petition. So, and there's a handout in your materials that shows the path of the case. So as I go through the rest of the slides and the information, you can always refer to that. But please don't feel like you have to know these time frames and the timelines. I mean, that's one thing that's great with our program, is you'll be working as a member of a team, that you'll have an attorney as a member of the team, and you'll have your child advocacy manager with the program that you'll work with as well. So any questions that you have about the chart or as things are happening in your case, you'll be able to ask them. So we provide the path of a case just as a point of reference. There's a lot of boxes and arrows, so don't worry about that. Okay, so we're at the point that we have a shelter hearing. Now, shelter hearings have to be held within 24 hours. And they're held 365 days a year. Now, we know, or you may know, that the courts generally aren't open on the weekends. Cases are heard Monday through Friday, but abuse, domestic violence, people getting arrested doesn't happen just through the week. So on the weekends, there are duty judges that are in court and are hearing cases. So the case, when it comes in, the case has to be reviewed within 24 hours. If the judge that hears it is not a juvenile judge, the juvenile judges that are familiar with dependency and delinquency, family law, it will then be heard again. So they'll make a decision, it gets heard, but it's reviewed the following Monday by a juvenile court judge. So everybody that's involved, whether it's the counsel for the department, which in our case is the state attorney's office, the guardian ad litem program, and so forth, will be at the hearing on Monday to review the case before the dependency judge. Okay, so a shelter petition's filed. They'll have the petition. The CPI that had went out and investigated the abuse call will be the one to sign an affidavit. So they just swear to the facts as they know them or as they observed and what they believe to be true, and allege that the child is in danger of harm, is abused, abandoned, or neglected. Okay, so that shelter packet will be provided to the clerk of the court, and the judge also gets a copy. The state attorney would have a copy. And when the parents show up to court, they're provided with a copy as well. Okay. So at the hearing, the parents will be advised of their right to counsel. Now, if they can't afford counsel, it can be appointed for them. There's a process for that. They're given the counsel then, but they have to be indigent and not have enough money to pay for counsel. Now, the judge will rule on the petition, of course, so the child's been removed, and the judge looks at the allegations, and there may be testimony from the child protection investigator, or the attorney for the department may just argue what's in the affidavit. That the CPI, the child protection investigator, are at these hearings and able to provide testimony. The parents also have an opportunity to provide testimony at the hearing as well. In different circuits around the state, shelter hearings are held in some different ways. Some will go really long and a lot of testimonies provided, and some are a lot shorter because the standard of review, what the burden that the state or the CPI has to meet for the removal is just probable cause. I mean, if just like in criminal, I mean, probable cause is real easy to meet. Now, if they're removed, the children should see their parents within 72 hours. Ideally, depending on the area and the resources in that area, the visits are supervised, so there has to be someone able to supervise. Now, if the parents provide a name of someone that can be approved by the department or by the court, then visitation will occur a lot sooner and generally more often in those cases. Okay, so the shelter hearing's actually the first opportunity for our program to be appointed. Okay. So we're at the hearings Monday through Friday if a shelter comes in. So we're generally provided with that information and have an opportunity to review it as well, but we wouldn't be privy to any of that information before the hearing. So we're hearing it as it happens. Now, anyone can ask in the court for us to be appointed. The child protection investigator could request it, the parents' counsel could request it, the parent could request it, and then, excuse me, the judge will rule on that. At this time, the goal is for every child in the dependency system to have a guardian ad litem. At this point, we're not at that level yet with resources, so we have to prioritize the cases. So the judge will look at the case and determine whether we're going to be appointed. Cases where the children go with relatives or sometimes stay in the home with the parents, we may not be on those cases, but circumstances may be that we are. So first we want to be on the kids that are in foster care. And it's hard. It's hard when the cases come in from the attorney's perspective. We're the ones that are in court and reviewing the petitions and looking at the allegations, and you see a history of what's in the home. We want to be on all the cases, but that's not possible at this point. But everyone here is helping us get a little bit closer to reaching that goal, so thank you. Okay, so after the shelter here, after the evidence is presented at the shelter hearing, there are certain outcomes that the shelter order needs to have in it. The judge is going to rule on certain things and address others. And this is only a partial list. In here, there's a lot of other things, but these are the main ones. First, if they were removed, are they staying out of the home? Is the judge going to affirm the shelter and say, yes, there was probable cause, so the child's staying out of the home? If not, the child can be returned. The judge could order the child returned. So depending on the circumstances, the child could go home. I haven't seen it happen a whole lot, but it has happened before. I mean, you hear stories where someone's made a false call on somebody, neighbors disputing, things like that, but that very rarely happens, because generally when the CPI or law enforcement goes out, they see what's going on and there's no removal to begin with. But on occasion it happens. If they remove, the judge will determine temporary placement for the child. They may already be in a placement if they found a relative or a non-relative, someone the child could stay with. If so, the judge can just approve that. Excuse me. Okay. And the parents have an opportunity at the shelter hearing as well, if names weren't provided, to provide names at that hearing to be looked into for possible placement. They'll determine parental visitation, what type, whether it's supervised or unsupervised. Generally, if you're at the shelter hearing stage of a dependency case, it's going to be supervised. Sibling visitation if the children aren't placed together. Now, the shelter order should state the reason that was provided by the department, or should I say at the shelter hearing, the department's required to provide the reason why the children aren't placed together and what efforts that they made to try to place the children together. I mean, there are cases where you don't want the children placed together because maybe one child's the perpetrator on the other child. But sibling visitation should occur at least once a week. Studies have shown that the bond that siblings have is one of the strongest bonds, because generally with the age, it's the longest life relationship and bond that you'll have with someone, even above the parents, because generally your parents die before the children do, and in that case you have a lot more years to add into that relationship. It will address home studies. So if the parents provide names, home studies have to be done on the placements before the children can be placed there. Now, I say home studies, but if they start out with the background check and the person they provide has a long list of disqualifiers, whether it's a criminal record, prior child abuse calls, a drug history, then they wouldn't have to go out to their house and finish looking at the residence and where the children would sleep and so forth. If services for the child, if there's something that's needed for the child, it's addressed at that hearing. There's no need to wait to see if there's an adjudication, they have a dependency case, a case plan, anything. If services are needed, we want the children to receive those as soon as possible. And even at that stage, the parent can have voluntary services if they request those. And many times you may only have one parent in court, and the other parent may live in another state or live somewhere that no one knows where they're at the current time. So a diligent search will be ordered to look for them if we don't know where they're at. So I know I've mentioned probable cause a couple of times. And again, just to reiterate that it's the burden of proof required for the court to affirm the removal. And it's a real easy standard to meet. So a few more details about the home study. It's done on any potential placements, obviously, except, when I say obviously, it's obvious to me, I guess, but foster homes, they've already been through that. They're licensed. They've been looked into. So if the child's placed in foster care, there's not a new home study done. When the case opens at shelter, the home studies will be done by the investigator that goes out. Now, maybe later on in the case, they can be done at any time. If it's done later on in the case, it may be another agency that's doing it. But anytime a child's going to be moved into a placement that's not licensed care, there needs to be a home study. Even for the parents, the child's been removed and at a later time they're going to go back and live with the parents, they'll go out and do a home study on the residents to make sure it's okay. So, and there, the last comment there is an adult relative or the adoptive parent of one of the siblings is given priority over a licensed placement. Again, as I said, we want the children with relatives or non-relatives rather than someone they don't know. Okay. So they do background checks on all the residents in the home 14 years or older, 14 years of age or older. They physical inspection where they're going to sleep, water, electricity, what the budget is of the home. Now, the potential placement will likely receive funds to help provide care for the child if the child's placed there, but they have to be in a certain financial position to begin with. And it's not a real high standard to meet, but if they're getting ready to get evicted, then it's likely they wouldn't place there because it would just be another move for the child. And basically, can that home meet the needs of the child? Because you have the child may have medical needs or other needs that can't be met in that home. Okay, so the guardian appointment, the judge will appoint the GAL program, and we have an order that's signed that will then give us authority to go out and meet with people, investigate, get records for the children. And I mentioned earlier the case prioritization sheet, or just having to prioritize what cases that we're on. And they're given a score for certain factors. So it seems kind of, I don't know, sterile or cold, be looking at the cases by a number on a sheet, but we have to find a way right now because we can't be on every case. Okay, so the dependency petition is the next step. If they're sheltered, so they're in a placement, whether it's relative or non-relative, foster care, within 21 days of that shelter, a dependency petition has to be filed. That obviously has to allege abuse, abandonment, or neglect, and the department has to say that there's nothing that we could have done to leave the child in the home. Because if there was, they should have left them there and put that service in. And one big thing to remember as you start working your cases and going through your case, you'll get your first one, you'll be really excited about it, and different people have different viewpoints about the parents, but the purpose of the dependency system is to protect the child. I mean, the main goal is to ensure that the child's safe, not the punishment of that parent for whatever it is that brought the case into care. Now, that being said, if what happened was really egregious, they may have criminal charges as well, but that's separate from our case. We may have some involvement, but we're not dependency civil. So they're not, our probationers, and we're not there to act as a guard. The goal primarily in dependency is reunifying the family if it's safe to do so. It should be one of the last resorts to terminate that parent-child relationship. Okay. So when a dependency petition's filed, the parents are then arraigned. It's like a first appearance in criminal. But so they can come in to court, they're served with the petition, they're given a date. A lot of times the date's given. If the parent's at the shelter hearing, they're given the date then. But they still need to be provided the petition. So at that hearing, they can do one of three things: admit that what they said was done, the allegations are true; deny, which they say, no, I deny the allegations, that's not true; or they can do neither of those and consent, which just says, okay, I'll work some case plan, I'll get some services. I'm not saying I did it, but I will do the case plan so I can get my children back. Okay, and again, at every hearing, the placement of the child should be reviewed to see if it's a good placement, that it's working out well, that the child receives what they should be receiving, or is there a better place? Like, for instance, if they're in foster care, is there a relative or a non-relative they can be placed with? Okay. So, if the parents consent, then we can move on and set the next hearing, which is an adjudicatory hearing. So if they consent, then we can do the adjudication at that hearing. If they deny, then there's a trial. Okay. Now at that stage, it's a preponderance of the evidence is the burden, okay, which is like 51% or greater. So if the allegations meet that burden, then the parent, it will be found that they did what was in the petition, and the child will be adjudicated. Which, when we say that, it just means that the child needs the services of the state, that the state needs to watch over the family, and if the child's removed, ensure the child gets what they need, and to assist the family either with reunifying or eventually finding permanency in some other way. But it's always back to safety of the child. Okay. So whether the parents consent or there's a trial and they're found by preponderance of the evidence that the allegations are true, there'll be a disposition hearing. Now the judge could find that that the burden wasn't met, and in that instance, the child would be returned. That would be the end of the case. So, but if not, the disposition hearing's held. Now, prior to this, the child welfare case plan has services and tasks, and it has a goal in it that is the goal of the case. That should be provided to everyone and provided to the court prior to the disposition hearing. Many times that doesn't happen. The case plans generally, if the parents are involved, they're at the case planning session, so they know what the tasks are. They've already agreed. There may have been a mediation. A lot of times between the shelter and the arraignment, we may go to mediation and everybody agrees on what the task should be, and then the parent will come in and consent. But so the case plan establishes the goal of the case and what the parents need to do, and it also contains things needed for the child or things that the custodian has to do. Now these tasks or services, you'll hear them referred to in several, in one of those terms. Part of your job will be to go talk to people, get releases signed by the parents. Now there is a portion of the statute that actually provides some support for being able to get information on the parents, even if they don't sign releases from providers. A lot of providers are resistant to that with a lot of the confidentiality and HIPAA type of regulations. So we generally get releases in our circuit. Some other areas, they'll get court orders or both, because some parents don't want to cooperate at all, and we may have to go in and get a court order. So there's some variations of what may happen. And you'll talk more about referrals and services in a later class. And at the disposition hearing, they'll set a hearing for 90 days out to review the progress that the parents have made regarding those services. Okay. So as I stated, there are permanency goals that in the case plan there has to be a goal. Now here we have listed four of the goals. There's actually 5 listed in the statute, but the primary one is reunification, because the purpose of the dependency system is to keep families together, to make them stronger, have children be safe, and be with their family. So that's the primary permanency goal. And at any point during the case, if the court determines that the parent have complied and done what they need to do, and that risk is gone and it's safe, the children should be returned home. Okay. The next one is adoption. So if you can't reunify with the parent, then we will look to the next in order, which is adoption. Now, in order for an adoption to occur with someone, the parental rights have to be terminated. Okay. So, and to terminate someone's rights, the standard is a lot higher. It's clear and convincing. There have to be grounds for that have to be proven at a trial. And most common is the parents aren't doing their case plan. They're just MIA. They've abandoned the child. Some egregious conduct towards that child, or a sibling or another child that's involved with the family. Or the parent may be incarcerated for a substantial portion, which is like 60% or greater of the age until the child turns 18. Okay. The next one is permanent guardianship. Okay, we'll look to that one if neither reunification or adoption is able to be reached for the child. Now, under permanent guardianship, to close the case, they have to have been in that placement 6 months. Okay. Now, permanent guardianship, it doesn't terminate the parental relationship between the parents and the child, so they're still on the hook for child support. They still get visitation. The type of visitation depends on the case and what the circumstances are. And jurisdiction is retained by the court in those cases. So even though it closes, the permanent guardian has committed to keeping the child until they're 18. Jurisdiction's retained in case for some reason they need to come back. The court still has oversight because the parents still have their rights and the child's placed with somebody else. And another one, which is mainly the last one, as I mentioned, there's 5. The other one is a fit and willing relative, placement with the fit and willing relative. The case stays open until the child turns 18. And actually now we have extended foster care, so it's older than that, but you'll also get to that in some later training classes. But with APLA, it's the last one we usually get to, because we prefer not to see children age out of the foster care system or stay in it for a long time. We like to get permanency within 12 months. The statute wants that to happen. And that's the goal, and what we try to have the parents remedy whatever the problem was and make it safe so the child or children can go back home. But to have a goal of APLA, the foster child has to be 16 or older. Okay. And at that point, generally, they're in foster care. They may have been there for a long time, and that foster parent agrees that they'll be able to stay there. And, of course, when no other options available, because obviously reunification's the primary. Adoption, that's really permanent. You're done, like it's the relationship through an adoption is a legal and a solid relationship. It is as if that child were born to the people that adopted them. Okay. So just to kind of summarize, we've talked about a lot of different hearings. I know I've mentioned things that happen at a shelter, and I've mentioned CPIs and state attorneys. You know, the guardian program gets appointed, and then we have members of the team. We have parties and participants in the hearing, and so we'll touch on those. Again, your training, you'll be provided with a lot of information during your training. You'll be provided with resources that you can refer to, and always as a resource, talk to your child advocacy manager, the person you work with in our office, or the attorney that's on your assigned case, if you have any questions. Okay, so who are the parties? The petitioner, which is generally the petitioner is an attorney for the Department of Children and Families, which is DCF. But the CPI and the state attorney, in our case, in other areas it may be DCF or an attorney general, but they're generally the ones that file the petition which brings the case in. Okay? The parents of the children are a party. The child's a party. The guardian program, when we're appointed, as I said, we're not on all cases, but when we're appointed, we're a party to the case. And then if the child is part of an Indian tribe, they can also be a party. They'll be contacted, and if they want to be involved in the case, they will be a party as well and be noticed and have the right to attend hearings, file motions, make requests, request to take custody of the child. And participants. So participants can be a huge group of people. It covers pretty much any person who's not a party, but who should receive notice of the hearings involving the child or the children. So who would some examples be? As you can see up there, foster parents, relatives or non-relatives as custodians. And as the case moves along, a participant could also be an identified prospective adoptive placement for the children. But as I said, pretty much covers anyone whose participation may be in the best interest of the child, because we want all the people that we can have that care about the child, that can provide information about the child or the family that gets them permanency the quickest and ensures that they're safe and that the children receive what it is that they need to be safe and happy mentally and physically. So I'll end it here in the sense for the next class, and that's the reason why we're covering it here at the end with parties and participants, that who is who, because when you go out and start talking to people and sharing information and getting information from people, the levels of sharing that information depends on whether the person's a party or a participant. Again, as I mentioned, confidentiality, we'll talk about that a lot, and you'll hear it mentioned a lot. So on that, we will end the session. Thank you.